Please be seated.
All right. Mr. Savage. Yes, sir.
Thank you, Judge. I'm concerned after reading the statute, which I should have done before I spoke, that the language of the statute is that if it returns a second time without having agreed upon a verdict, it shall not be sent out again without its own consent unless it shall ask from the courts further explanation of the law. So the concern I would have in the strict construction of that statute would be that the initiation of the request must stem from the jury, not to be suggested with all due respect by the court or anyone else. So not having heard a request on its own, request emanating from the jury itself, but rather at the suggestion of the court, we think that's an inappropriate and improper interpretation of the statute. Your Honor, there's another concern that I have in thinking of the note that you have received from the individual juror who wrote to you not through the foreman but on their own. It appeared that there was an emotional basis discussed in that letter regarding an improper consideration by that juror, or potential improper consideration that may reflect an argument that is being used to convince that juror to change their mind. I don't know that. I don't think it would be proper to interfere or make any inquiry into the internal discussions and arguments of the jurors in the jury room. It does concern us that there is an emotional basis for his concern to stay with his interpretation of law and facts. It may very well reflect the argument of other jurors, which would be an improper basis. So again, we would move for mistrial at this time.
Ms. Wilson?
Your Honor, have we heard from the jury again?
No.
Okay. We oppose the mistrial motion at this point. As we all have discussed in all of our collective experiences, figuring out what a jury means by a note or a juror means by a note is often fool's folly. You basically read the statute to the jury, letting them know how the procedure works. And the foreman offered that perhaps more instruction would help. I think looking at the afternoon or the day in its total, it may be, and again, we're all just guessing, it may be that the one juror who's having an issue is having an issue because of a lack of understanding the plain and ordinary meaning of some of the words of the charge. You've asked, I would note just by observation that yes, the foreman spoke about further instruction, but several jurors were nodding their heads as if further instruction might help. They are now back there and they'll let you know. I'm sure that the one juror, if he thinks that or she thinks that further instruction won't help, they know how to contact you, they know how to relate through the foreman, and I think we just need to wait and see what happens at this point.
All right. The one case that talks about dealing with the issue when the jury has twice indicated it is deadlocked is a case of Buff versus South Carolina Department of Transportation, a Supreme Court case. And that case says that when a jury has twice indicated it's deadlocked, the trial judge should diplomatically discuss with the jury whether further deliberations would be beneficial. And the jury's consent to resume or to discontinue deliberations is determined either expressly or impliedly by its responses to the judge's comments. So I've explained to them the laws, what the statute requires, and as diplomatically as possible attempted to ascertain whether or not the further deliberations could be beneficial, and the foreperson indicated that he thought it would be. Certainly, we've only heard from the foreperson, but the foreperson is the spokesperson for the jury. That's what a foreperson is. That's what a foreperson does, speak for the jury. As indicated, I did not solicit a numerical division. I would think that the jurors are probably it's probably rare that they start off unanimous. Those verdicts we get in 10, 15, 20, 30 minutes. So we've been here this is the third day of deliberating, so the mere fact that it's taken 3 days, you would know that there had to have been some numerical division at some point. In the case of the State v. Williams, Supreme Court case from 2008, the court discussed whether the judge, in giving an Allen charge, after hearing about the numerical division, whether the Allen charge was coercive toward the minority of jurors when the jurors sent out a note saying that they were, prior to the Allen charge, sending out a note saying they were deadlocked 9-3, and, well, actually it's a death penalty case, 9 for death and 3 for life imprisonment. And the judge brought them out and gave them the Allen charge, and the claim there was that because the court knew the numerical division, the Allen charge was therefore coercive. And that argument was rejected in that case. And finding that that since the court did not solicit numerical division, that there is nothing coercive in having the jury continue deliberating after discovering the numerical division. Contrast that to State v. Barnes, where the jury told the judge that they were deadlocked, and I think it was the second time around, and the judge says, well, we'll send you home and get some rest if you'd like to, and after that, if you think it would do any good, we can do that and let you come back tomorrow. And the foreperson says, well, Judge, I don't think it would do any good. But despite that, the judge sent them home, and they came back the next day and found the defendant guilty. The court in that case concluded that because the jurors clearly indicated that further deliberations would be of no benefit, the court erred in having them come back the next day in violation of 14.730, that the court erred in failing to declare a mistrial. So we have a situation in this case where it obviously doesn't occur very often, and frankly, I expected the foreperson who sent a note saying that we're deadlocked, that come out and says, yes, we're deadlocked, but he said the opposite and said that he thought further deliberations would be of benefit. And under the law, in that instance, the jury, he said a further explanation of law would be of benefit, and I don't know what explanation they want. And a solicitor, you seem to think you know what I need to explain to them, but they didn't say what they want. Yes, ma'am.
I'm not just making that up. I mean, that came from the note that we received earlier. Now, whether or not they've moved on from that, you're right, I don't know. And I'm hoping that they're going to let the court know. I'm not suggesting that you just bring them in and go back to where we were this morning and charge them, but hopefully they'll clarify what aspect of the law they think may be helpful.
Yeah, well, though the law is, the statute is, Mr. Savage indicates, is silent as to the exact process. The court did not solicit or encourage them to say, yes, we want to go deliberate further. That was initiated by the foreperson in response to the statutory scheme that we've set up to elicit whether or not further deliberations would be beneficial. Now, I think the best that I could do is have the jury come out and let's be clear, are you deadlocked or are you still deliberating? And if you're still deliberating and want further explanation regarding law, what do you want me to explain?
I thought that that's where we left it last time with the exception of the last line that you just said.
Well, I told them I would have them come back in, so they might be expecting to come back as well. I would think that they are. I told them I would confer with counsel and have them come back. And that was a half an hour ago at this point. So if you would bring them back in.
Judge, are you going to ask them what explanation
Ask them
you thought would be helpful?
whether they're still deliberating or have they reached an impasse, or are they
Well, the last thing that the foreman said was that he believed further explanation of the law may help, and I would just ask that you lead with that. What explanation of the law?
all right.
I think Your Honor was correct the first time.
Okay.
Are they deadlocked?
All right.
All jurors present, Your
All
Honor.
right, thank you. Mr. Foreman, your last in, it was with the note that you were deadlocked, and upon inquiry by the court, you indicated that you thought that continued deliberations might be beneficial, or the further explanation of the law might be helpful by the court. I need to know whether the jury is at an impasse that cannot be broken, or are you continuing to deliberate and want further explanation of the law from the court, and so what law you would like the court to explain. So what is the status of the jury at this point?
That is what we want, desire to continue to deliberate.
And if the jury desires further explanation of the law, please inform the court as to what law you would like to me to give further explanation concerning.
Yes.
All right, and if you'll do that through a note, we'd appreciate it.
Thank
All
you.
right. Now, it says the state. It says the defense.
Not we again for mistrial based on the note that the court received at this point, the coercive factor is concerning. I don't know how long ago that was when the court received the note from the jury that said he or she was unable to find guilty. How deliberation is defined is unknown to us, and my concern would be coercion.
Yes. And I certainly understand it, your concern, and the court indicated to the jury and instructed the jury that any note that you wish to submit to the court should come from the foreperson, signed by the foreperson, and this note came directly from the juror. Typically, the parties do not get any window into the inner workings of a jury as to where they stand and how they're seeking to make a decision. Ultimately, if there is a verdict in this case, the jurors will be polled and they would have to affirm that it is their individual verdicts if we reach that point. And if we do not reach a verdict, then we will not have a verdict and a mistrial must be declared. But at this stage of things, with the jury indicating a willingness and an interest in continuing and requesting to continue deliberating, it would be improper for the court to declare a mistrial. So, all right, so we'll be in recess.